it often feels like the structures through which those decisions get made, sort of the institutional levers of power within the city and state, are rigged against us. And I don't think that that feeling is inaccurate. Um, Zoning and land use, which we will be covering tonight, I think are an especially good example of that issue. The system is very much rigged to favor property owners and developers, and that is hugely problematic because zoning and land use can go a long way to determining the character of a neighborhood, to change the character of a neighborhood, to maintain it, which are all things that we have been um, seeing play out in Chicago over the past years and decades. I would like to take a moment to thank Alderwoman Rosana Rodriguez and her staff for their tireless, often thankless work around this and all of the other issues which come before them. I'd like to thank all the 33rd Ward Working Families members who have done work around this. Specifically, I'd like to shout out Liana Miller Marquez in the ward office and Karen Sandler as a member of 33rd Ward Working Families. Who've both been very diligent in their work around these issues. As an organization, we're hoping to develop a defined platform around zoning and land use and to build up the structures through which we can fight for that platform and respond quickly and appropriately to any proposed developments we would like to advocate for or to fight against. This educational event that we are putting on this evening is intended to be a part of that process. In the US at large, zoning and land use are areas of public policy that have been mystified to discourage working class participation, and largely that has been successful. It will likely not surprise any of you that Illinois makes the process even more confusing than it is in other places. And joining us to help shed some light on these areas is Ramson Cannon. Ramson is a comrade who wears many hats, or probably more accurately, many suits. He was the longtime political education coordinator of the Chicago chapter of the Democratic Socialists of America, where he oversaw the development of the Socialist Night School and various other very successful educational programs. By trade, Ramson is a lawyer. During the uprising against police violence last summer or last year, he helped Rosanna and some of the other leftist alder people with jail support for those who had been detained by CPD for exercising their right to protest. By specialty, Ramson's law practice focuses on zoning and land use in addition to labor law. So we are very grateful for Ramson to take the time to share the presentation he has put together with us. And with that, I will hand it over to Ramson.
Thank you, Nick. Thanks so much for having me. Thank you, 33rd Ward Working Families, for having me present on this topic. I'm going to share a presentation that I prepared for this to discuss zoning for organizers, land use. It's going to be, it's a very technical and challenging area of law in a lot of respects. And I didn't want to make it, so the challenge is always to figure out how legally and technical you want to make it, also how much knowledge you should assume in your audience. So I tried not to make it either too basic, and I tried to avoid legalese as much as possible, although you are going to see case citations and stuff in there because we can't help ourselves sometimes. So just be prepared for that. Again, I want to echo Nick's thanks to the Alderwoman and her staff, particularly Liana, and the hard work they've done on a very challenging area of policy. And with that, I think I'll just jump right in it. You can let me know if everybody can you see that? Okay. I'm not a particularly adept design person, so you'll forgive me if it's not particularly fancy looking. I know Nick referred to it as zoning for activists. I wrote zoning for organizers there. Is my preferred nomenclature. And I'm going to kind of divide this into 5 parts. Going to talk a little bit about the legal basis, the constitutional basis for zoning, the idea of takings and takings law, which actually has a lot of direct and indirect impact on how organizers interact with zoning, zoning processes and individual rights and how they play into it. The possibilities for activist zoning under something that's called Nolan Dolan, which we will get to, and is very fun to say. And finally, the political economy of land use. One thing I'll just go ahead and say sort of up top is that today it was announced that Southside Recycling, which is the company that wants to operate a scrap metal recyclery in the 10th Ward, filed a lawsuit against the city that I think, and that lawsuit actually brings up a lot of issues that are relevant to our work here. So I'm going to throw out some of the case studies I had, and you'll hear me referring to that throughout the presentation. And I'm sure we'll have some questions on it at the end. Okay, so the basis of zoning. Like I said, this presentation is really meant to provide some basics and fundamental understanding of zoning and land use and how it works legally, from not just from like a litigator's perspective, but just in terms of the way the laws actually work and the way they're written, who they're meant to benefit. Because I think that can help organizers understand how to attack the issue when it comes up as a matter of policy. Understanding the root of it, understanding the contours of it, and the basics of it, I think can really help people wrap their mind around coming up with, as Nick said, a strategy for an organization like 33rd Ward Working Families to address how a political organization is going to orient itself to zoning questions. So I'm not going to go into so much detail of the City of Chicago zoning code for some reasons that we'll discuss, but really try to provide some of the more fundamental basics. So the legal power, the legal basis for zoning comes from what's called the police power. And it says here the state's police power. And the state here means not just the state in terms of like the government, but also the state of Illinois. In the United States, the states are considered sovereigns that have what's known as the police power, which is a general power, a general sovereign power to regulate for the health, safety, and general welfare. This is something that it's generally understood that Congress does not have, the federal Congress does not have the police power. It has enumerated powers that are listed in the Constitution. So therefore, unlike in other countries where there are sort of national planning laws and zoning laws, the United States, the states have the power, this police power, which in general they delegate to cities and counties and other localities, they're referred to sometimes. And this is the power to regulate the uses of land. In Illinois, the specific powers are granted and defined by a state statute. In Illinois, that's in the Illinois Municipal Code, which is found at, you'll see the first citation there, 65 ILCS 5, Article 11. ILCS stands for Illinois Compiled Statutes. Along with with Chicago's general home rule powers. What that means is under the Illinois Constitution, cities of certain size, unless they decide to reject it, have what's known as home rule authority, which really just means that they kind of are also their own mini sovereigns. They have general powers to regulate unless the state denies them that power. So the example you've probably heard of that is the right to regulate for rent control. The state of Illinois chose to pass a law at the state level that denied home rule cities and counties the power to impose rent control legislation, because if they hadn't passed the ban on rent control because of the home rule authority, cities would have been able to impose rent control. These zoning powers and home rule powers are limited, though, by a number of doctrines and laws. And you see a list of them there. The Fifth Amendment to the US Constitution, um, sometimes known as the takings clause, and that's applied to the states through the 14th Amendment. In specific cases, the First Amendment restricts the zoning power, in particular when it deals with the free exercise of religion. And one example of this is a federal law that's known as RLIUPA. You see it there, which stands for Religious Land Use and Institutionalized Persons Act. And there is a somewhat recent case example of this called St. John's versus City of Chicago. In other narrow cases, the 14th Amendment's Equal Protection Clause limits what the city can do around zoning. The Illinois State Constitution, sections 2 and 15, which are kind of just echoes of the federal constitutional protections. Some federal environmental statutes, the Environmental Protection Act, the Clean Water Act, and CERCLA, which is also known as the Superfund Law, which are environmental laws that are rooted in the in Congress's Commerce Clause powers. Congress has the power to regulate things that impact interstate commerce, and also has powers to regulate things that impact the waters of the United States. So that's why CWA and CERCLA are able to be federal laws. And then finally there at the bottom, you see common law doctrines and constitutional doctrines of nuisance, what's called tortious interference, and due process. And these are kind of summed up in something that's unique to Illinois that are known as the LaSalle factors. They come from a case called LaSalle National Bank versus Cook County of Cook. So what does zoning look like when you actually kind of look at a map or look at the City of Chicago zoning code? For one thing, if you just do a search for City of Chicago municipal code, you'll see you'll see that, and you pull it up in the Muni Code library, you'll see that the zoning code and the planning code are broken out from the rest of the municipal code. And that's because there's a variety of reasons for it, but one of the main reasons is that they're so big. They're very dense, very detailed. And to give you a sense of what zoning actually looks like and does, here's a zoning map. And we're going to look at two examples from the zoning map. So this area might be familiar to some of you. And there you see RT4 is one area, the way one area is zoned, and C2-2 is the way another area is zoned. And we'll look at what that means. So when you see that on a map, how should you interpret that? Well, if you go back to the zoning code and you look up RT4, you'll see that R denotes that it's a residential district. So that means residential uses are permitted there. RT means that it's residential 2-flat townhouse and multi-unit districts. So that means in that district, as it says there, the primary purpose of the RT district is to accommodate detached houses, 2-flats, townhouses, and low density multi-unit residential buildings. And here you see a table. And one of the important things to understand about zoning and the way that zoning exists in most places in the United States is that it's use-based. So to go back to the map, what all these delineations are showing is what on this piece of land, what uses can the property be put to? If it's designated with an R, you can put it to a residential use, and then the zoning code will include a table like this that breaks it down. So if you look at RT, and then that's the use category, and then the use type is 4. That means it's this residential 2-flat, et cetera. And then it'll have a list underneath, and you see the legend there that says if it's denoted with a P, that means it's permitted by right. That means any use where there's a P next to it means that the person who owns that property by right can commit the property to that use. If there's an S, that means they need an additional, what we call entitlement. That's a special use. So they have to get additional approval to put it to that kind of use. If there's a dash there, it means it's not permitted at all. And then plan development approval is something kind of separate that we can discuss a little later. But you can see here, they'll give you a table like this that lists everything out. So in the RT4 detached houses are permitted, elderly housing is permitted, 2 flats, townhomes, et cetera, all the way down. Once you get to the bottom there, you see temporary overnight shelters, skilled nursing homes, et cetera, are denoted with an S. That means a special use approval is required. The -4 refers to sometimes what's known as the intensity of the use. So the use category is RT, the use type is 4, and then the and then the -4 indicates these bulk and density standards. So that's the intensity. So what that means in this case is, how big does the lot have to be? What is the floor area ratio or the bulk? The floor area ratio is what it sounds like. It's the amount of floor space as a ratio of the total lot size. So because obviously if you have 3 units of floor space versus 7 units of floor space, that's a lot more intensity on that piece of property. So floor area ratio determines that. Setbacks is the distance of the structure that's being built from the lot line, meaning from the boundary of the property. Building height speaks for itself. And then you have character standards, which are other things that the zoning code will specifically spell out in terms of the character of the property. Sometimes that has to do with like the type of materials used and different sort of physical characteristics of the structure that can be built in that zone. The other zoning designation we looked at was C2-2. Generally, B and C are business and commercial districts. They're intended to accommodate retail, service, and commercial uses, so just what they sound like, and can also have residential uses. They can often also have residential uses above the street level. C2 is a very high density or high intensity zoning designation. It's kind of properly defined there as motor vehicle related commercial. So you can probably assume what that means. That means it has a parking lot, so like a strip mall. And the purpose there is to accommodate business, service, commercial uses that are going to have a lot of vehicle traffic. And the bulk and density standards here are indicated by the dash after the -2 after the C2, and the higher dash, the higher the minimum standard usually, and that usually applies to the type of residential that's permitted in that zone. But here again, you see that table that first, it has the use category, then the use type, so C2, and then the table actually breaks down what's permitted and what requires a special use. So what requires an even higher level of approval from the city. A drive-through facility will always require a special use, and you can imagine why. If a building, if somebody wants to build something where there's going to be cars queuing up and turning off of the street and back onto the street regularly, the city wants to be able to evaluate the plan and make sure there's not too many of those being built so that it doesn't impact traffic and pedestrian safety too negatively. Outdoor patios, you can see there in section AA number 4, again, because that can impact, noise that's being created in the neighborhood and quality of life stuff. Intertrack wagering, they don't want too many OTBs, off-track betting facilities and stuff like that. So this is the way the zoning code, this is the way the zoning actually works. The properties, the land is subdivided into zones. The zones are classified by use and use type. And then each use type has associated specific uses that are permitted or not permitted, and bulk and density standards like lot area, floor area ratio, et cetera. So here are some sort of common zoning activities when we talk about zoning. Some of them are obvious: rezoning an area. So somebody buys a piece of property that's zoned, for a single family home, and they want to upzone it. So because they want to build something bigger, they want to build townhomes or an apartment building. That's known as an upzoning. Sometimes people want to downzone it. Downzoning usually is done by the city. And so, that's also sometimes referred to as a map amendment when you're rezoning a single piece of property or a few pieces of properties. When you're rezoning an entire area, which is obviously something the city is most likely to do. So if they decide, this whole stretch of Montrose, we want to upzone to allow more, bigger buildings to be built. Um, that would be an upzoning that would most likely be done by the city. The standards for map amendments or rezonings of this type usually require that an individual property's rezoning fit in with the properties around it. Now, fit in, there's all types of criteria that the city will look at. So fit in doesn't necessarily mean that it has to be exactly like what's around it, but it can't be too anomalous. And if it's much different from what's around it, that's sometimes referred to as spot zoning, which under certain circumstances is illegal in Illinois. And sometimes is evidence of what's called contract zoning, which basically is when a developer comes in and says, give me this in exchange for me giving something to the city, give me this zoning. And as a question of political economy for organizers, you can understand why upzoning in particular would be very attractive for developers, because the more floor area, especially for commercial uses, but this is true for residential uses too, the more floor area you can put in, the more valuable the property is to you, because things are calculated by value per square foot. So if you can put more density on a piece of property, all the better for you. But it also works the other way, where sometimes in particular groups of property owners might want to limit how much floor area is in a certain zone or area of the city, because they want to sort of create a cartel basically that protects the value of their home or their property by limiting how, if it's a particularly nice area, they don't want it to get overbuilt, because then that could decrease their property values. Site plan reviews are is an approval that's required when there's going to be usually slightly more complex, not necessarily though, redevelopment of a property. So often if they're knocking stuff down and rebuilding stuff, they need to get an approval for what's known as their site plan, which is just what it sounds like, an architectural rendering, an engineering rendering of what the site, how the structures are going to be situated on the site. Special use permits. We discussed these a little bit on the previous slides, but special use permits are discretionary permits that the city can issue for, usually it's for more intensity creating uses. So the examples you saw on the previous slides were drive-through businesses. The city doesn't want people to be able to build that by right. They don't want somebody to be able to buy a property and just have a permitted use be a drive-through, because if that were to happen, the city would lose its ability to control how many drive-throughs are going in a certain area. And drive-throughs are intense and potentially disruptive uses. And that's also true for other types of uses you can imagine. The outdoor patio is one that we saw, but off-track betting would be another one. There are just certain activities that you want to make sure that the city would want to make sure it can determine whether that type of intensity or disruptive use going into a neighborhood or a certain block is justified. Variances in Chicago, they're actually known as variations, but in sort of common parlance, they're known as variances. Variances are basically exceptions from the law. So a variance is when somebody goes to the city and says, the use standard. So for example, as you see on this slide, the setback for this RT4 zone says that my building can't be less than 30 feet from the property line, but I want to build a garage. So that requires, if I build a garage, I'll only be 5 feet from the property line, or 3 feet, or 0 feet from the property line. And so I want a variation from the requirement of the code, basically an exception from the code. And obviously that's something else that the city requires an applicant to go through an additional process, because in theory, it should be very difficult to get a variation, because otherwise you're asking for an exception from the law. You're basically saying, I don't think the law should apply to me because I want this, this extra entitlement or zoning relief, sometimes it's called. And so the city is supposed to turn a very critical eye to those types of applications. Sign permits, there's some First Amendment issues that sometimes come up with sign permits in terms of how they can be denied, obviously because signs include a form of expression. Creation and modification of overlay districts. That's kind of a specialty issue I won't really get into. And then planned developments. Planned developments are a very important zoning key that are pretty complicated. Planned developments basically usually entail lots of different pieces of property. Actually, I wonder if there are any PDs here. Yeah, I think this might be a PD potentially, but a planned development is basically when there's a bunch of properties, usually, or one very large piece of property that's going to have a mix of uses in it. So a developer buys the piece of property. Actually, Lincoln Yards would be one example if people are aware of that project. You know, I bought this huge piece of property and I want there to be a bunch of stores. I want restaurants with outdoor seating. You know, I want some luxury condos in there. You know, and I want a logistics hub for the, you know, to supply all the shops that are going to be there. I want all these uses in one place, but there's no single zone that would allow any of this. So what I need is a PD. I need a planned district that allows for all these different types of uses. And the city basically creates those, has to create those. And usually it happens through negotiation with the developer, where the developer has to, you know, there's very specific criteria in the zoning code that says, if you're going to have this PD, you know, it has to be, you know, these kinds of underlying uses are permitted. So you're allowed to have restaurants, stores, this much housing, you know, and there have to be specific site plans. This is where the curb cuts are going to happen. You know, this is how much parking you have to supply, et cetera, and all those things. The decision-making bodies for each of these, you see here, the city council deals with text and map amendments. So that means a text amendment is an actual amendment to the zoning ordinance itself. A map amendment is what I described earlier, rezoning. And those applications go in front of the city council on zoning, the city council committee on zoning, and then eventually are approved by the entire city council. This is where the issue of aldermanic prerogative comes up that we can discuss if people have questions about it. The zoning administrator, who's an appointed official, is responsible for site plan reviews and certificates of zoning and occupancy, which are, you know, fairly minor approvals. The city's plan commission, which is an appointed body of commissioners, they conduct fact finding. So they conduct hearings. That's also referred to as fact finding, and they issue recommendations for tax increment financing districts and for plan developments, because they're major. As you can tell from what I described in a plan development, it's a major change to a neighborhood if you're putting in a big development that has all these different uses. So the plan commission has to review those. And the Zoning Board of Appeals, the ZBA, conducts fact finding and issues actual final decisions. The plan commission just issues recommendations to the council, but the ZBA issues final decisions for special uses and variances, because those always apply just to single properties, single applicants. Rather than plan development, which kind of affects an entire area and is more intense in its use. So I'm going to go through takings. I'll try not to bore you too much with the constitutional law of it, but it's good to understand the basics of takings law so you can kind of understand why zoning procedures exist the way they do. You might remember from your con law, constitutional, Illinois Constitution class, or your civics classes, social studies, that the Fifth Amendment includes a takings clause that says private property can't be taken for public use without just compensation. This was applied to the states by the 14th Amendment. And the Illinois State Constitution has a basically identical provision. When zoning started in the early 20th century, in the 1920s really, it was challenged in court as violating this clause. The argument was that it imposed a public purpose on private property. So it was essentially the government saying, you're not allowed to use your property how you want to use it, because we want to plan the city out to look a certain way, and we want harmonious uses to go together. The Supreme Court rejected that challenge in a case called Ambler Realty versus Village of Euclid, and this is why sometimes you'll hear the phrase Euclidean zoning, because of the type of zoning that was at issue in that case. But even though the Supreme Court rejected that challenge, and they said that zoning doesn't violate the takings clause, the cities have to be very conscious of how they regulate the use of land and the way they balance the individual rights of property owners with the public welfare. And the reason I say they have to be careful, I want people to understand, especially because this is being recorded, so I don't want to be taken out of context. The reason I say it's important is not because of some sort of libertarian idea of sacrosanct private property rights, but rather because of the city's desire to avoid constitutional challenges to their zoning decisions, legal challenges to their zoning decisions. And that concern, that protection that the federal courts have given to individual property owners sets some limit, some basic boundary for how zoning laws can be written and enforced. So over the last century, a very complex body of law that's also often just referred to as takings law has grown around city land use policies. And I indicated with very cool lightning bolts there that, you know, takings law essentially sets the background and the boundaries for how cities can use their zoning authority, which I think is really relevant to our topic today, because we are talking about a situation finally here in the city of Chicago where socialists, leftists, the left does have some state power to use when it comes to zoning. So let's look at that process and how those individual rights play out. This actually came up with the Southside recycling permit lawsuit. So that's going to give us a good object lesson and example to use for this. In general, there are three kinds of government actions that are at issue in zoning cases. These are known as ministerial, quasi-judicial or administrative, and legislative acts. Because zoning, more than almost any other government action, other than when the government is acting as an employer or as a incarcerator, it impacts individual property rights so heavily. Government actions that change a person's use of their property, their ability to use their property, are carefully scrutinized by the federal courts. And, you know, arguably the federal courts are the most concerned when it comes to people's individual property rights, their rights over real property, meaning land and structures. Ministerial acts is just a term for government actions that don't include discretion. So what that means is the government has a law and they say, you know, you can get this type of permit so long as you meet these objective technical standards. And if you meet these technical standards, a permit must issue, is usually the way it's put. And to make that less abstract and give you an example, building permits are usually considered ministerial permits. Meaning, if you look at the city's building code, which is separate from its zoning code, it will say, you know, if your property is properly zoned for, let's say, a single family home, you can get a building permit to fix or build your house, so long as, you know, you submit an application that has all these elements in it. You have to list the contractor and subcontractor. You know, you have to show that you're bonded or they're bonded, they have insurance, that it's properly zoned. You have to submit plans like architectural plans, et cetera, et cetera. It has to be, you know, you have to meet all the fire code standards and use the right materials, blah, blah, blah. And if you put all that in the application, you will get a building permit. There's no discretion involved. The city can't say, well, you meet all the requirements, but we're not going to give you the permit anyway. Quasi-judicial or administrative acts usually have a mix of discretion and policy questions. The best way to think of it is it's when the government is implementing a policy in a specific case. And in these cases, the applicants have strict procedural rights. For a long time in Illinois, well, not for a long time, but for a period in Illinois and in a lot of other states still, a lot of zoning activity, like applications and type of actions, are considered quasi-judicial. And the way to think about that is the city has the zoning ordinance that says, you know, if you want to build a drive-through, you need a special use permit. And that is the general policy of the city. And the general policy of the city is to get the special use permit, you have to show that, you know, you have ample room for turnarounds, and, you know, you have enough of a lot size to accommodate the cars, and you're far enough away from the intersection, and all the other standards they might have for a special use permit. And once you've shown that, the city will take that general policy and decide whether it wants to give you a special use permit. They don't have to give it to you, in theory. they still have the discretion to say no. And the discretion would usually be based on, there's already 6 other drive-throughs on this block. And if we give it to you, there will be way too many. And that's why they retain some discretion. But the law has sort of evolved to make sure that even though the city retains that discretion, it's not absolute. So that the applicant still has some rights. That's why it's called quasi-judicial or administrative. The applicant still has to be able to make their case. And the city's decision has to be supported by evidence. So it can't just blanket say like, nope, we don't want to give it to you. We have discretion, so we're not going to give it to you. We're not even going to tell you why. The third type are legislative acts, and these are general acts of policy. The zoning ordinance itself is a legislative act, but also usually upzonings of regions and stuff like that will be legislative acts. And when the government acts in a legislative capacity, policy level stuff, the courts will really heavily defer to the decision makers. What that means is if somebody were to sue to challenge a legislative act of the government, the court is basically going to tell that person suing, we are not going to overturn this decision unless it's really egregious. It's usually what's referred to as a rational basis standard. So what that means is the government in making this decision must have had no rational basis for doing it, meaning it has to be completely arbitrary or capricious, meaning like, they did it just to screw somebody over or, just out of caprice, for no good reason at all. In Illinois, Nick mentioned in Illinois, it's particularly confusing. Part of the reason it's confusing in Illinois is because Illinois blends these categories together, the second and third categories together to some degree, and it makes the process confusing, especially when you're trying to review a decision of the city's made. So if something's been approved for your neighborhood or the next neighborhood over, and it seems wrong, it seems like not something the city should have done, either because the project they approved, the zoning they gave it is too disruptive, or they're demolishing housing and not replacing it, whatever it might be, and you and a bunch of other people get engaged in the process, and afterwards you want to consider whether you can take some legal action. It can be really difficult to understand what your rights are both during the process and afterwards. And that's because of a 2011 law change that came after a case in 2006 that's known as People ex rel Claren versus Village of Lisle. Sometimes it's known as the Claren case. And that case, a bunch of residents in the Village of Lisle were fighting a Meijer department store or outlet that was coming there. And it devolved into a big fight in front of the Plan Commission in the city, the village board. And basically the court came out and said, these are quasi-judicial processes. The objectors, the people opposing the project, have certain rights. Basically, they have the right to cross-examine witnesses and all this stuff. And the state legislators freaked out because you can imagine they were getting calls from mayors and board presidents from all over the state saying, if this case stands, it's going to be almost impossible to do any major zoning work, especially things that will be unpopular with residents, particularly with NIMBYs, right? Not in my backyard types. And so in 2011, the Illinois legislature passed a law that says all these zoning acts are legislative acts. And so the courts have to defer to them. But they'll be reviewed by the courts, what's known as de novo, which means that the court, although they'll defer to the ultimate decision, they will review all the evidence themselves. And that's a legal technical difference that I won't bore you with or get into too much, but the effect of that means that although the court is unlikely to disturb the final decision, they do have the ability to go back and look at the process and the decision-making that went into the decision, much more so than they would in a quasi-judicial case where they defer to that process. So the process and individual rights. So just to run that down again, ministerial are building permits. If you meet the requirements, a permit must issue. Quasi-judicial apply to specific cases. Legislative acts are general policy acts. One thing to keep in mind, the way it worked before, prior to this 2011 amendment and its enforcement, the record for any decision was created at the local level. So what that means is when there was a hearing for a rezoning or whatever, the applicant would submit their application and there would be a hearing. They would show up, they give a presentation, a PowerPoint, their lawyer will get up there and talk about how great it was and how it's going to be so good for the community. As you can imagine, local residents would show up often to oppose the project, whatever it was, and they would get evidence into the record as well. Prior to 2011, once that hearing was over, the record was closed. And no extra record evidence was allowed to go in front of a court if they were reviewing the decision. Under de novo review, the record is still closed, but the court is allowed to consider reasoning and even potentially look at extra record evidence. That all got mushed together. And the result is now that the court will usually fall back on these things that are known as the LaSalle factors, of which there's like a dozen individual factors that I won't go through. But as you can imagine, that creates, when there's a dozen factors that have to be weighed when the court is considering whether a certain zoning action is lawful or rational, that can create a very challenging context for especially local residents to deal with when trying to challenge or involve themselves in a zoning issue, a zoning policy issue. So let's look at the process. This is the process for a plan development. This image actually appears in the zoning code. And you'll see there, it starts with the application filing. The plan has to go to the application. The plans that are with the application go to the plan commission. Plan commission hearing has to be scheduled. The zoning administrator reviews it and the staff issues a recommendation. The DPD, the Department of Planning Development, issues a recommendation. There's a public hearing. A notice is posted 15 to 30 days prior to the hearing. Then the actual hearing happens. They issue a recommendation that goes to the zoning committee of the council, and then the council makes ultimate decision. That's for a PD. And it's a similar process. Not for the PD, but a similar general process for the other zoning actions. What it actually looks like with the applicant is that they'll first, if they'll hire a land use attorney. Ideally, they'll go find someone who's well-connected. As you can imagine, there's a lot of well-connected law firms, some of which, are run by aldermen or former aldermen or family members of aldermen. They'll hire those law firms to go, and they'll go meet with the alderperson and they'll say, this is what I want to do with this piece of property. What do I have to do to get your support for it? They'll meet with the city staff, sometimes concurrently or beforehand or just afterwards, to see, is this application going to run into any trouble? What should I include, et cetera? Then the plan goes to the plan commission and it all works how I described. Ultimately, the council decides. And in Chicago, there's a technically informal tradition known as aldermanic prerogative, whereby the alderman will vote based on the recommendation of the local alderman. So if something's being built in a specific ward, the rest of the aldermen will defer to the recommendation of the alderman of that ward who says, so please support this or don't support this. And I'm sure people will have questions or comments about the aldermanic prerogative, but that's been sort of an informal tradition in Chicago for a long time, and it's been challenged before. Courts are generally unwilling to touch it. So now we get to what does this mean for organizers? The questions we ask when an application for something is going in front of the city, what are the relevant criteria for approval? Meaning what criteria apply to the type of application that is going in, whether that's for rezoning, a plan development or whatever. What are the conditions the city can impose? So what conditions can the city impose on the applicant? What are conditions the alderperson can feasibly request from the applicant? Can support from the community or from the alderperson be conditioned on those requests? In other words, they request, we'll let you build this if you promise to do X, and if you promise to do X, we will appear in front of the hearing committee and support your proposal. Obviously, some basic political questions: who's likely to support the proposal, who's likely to oppose it, and from a technical perspective, and this is where the organizing work and the structures we build at the community level to deal with these things become very important. What kind of findings need to be made, and what are the project's actual measurable land use impacts? So what does that mean? Well, because there are specific criteria that the city agencies have to consider, whether that's the Plan Commission, the ZBA, or even the City Council's Committee on Zoning. The zoning code lays out, as I described with this special use permit for a drive-through, for example, it says like there are certain findings and criteria that are required to get this permit. Like I said, the lot area has to be a certain size, curb cuts have to be potentially a certain distance from intersections, you know, et cetera. Those criteria are what the decision is supposed to be based on. And if the decision is supposed to be based on those criteria, the city doesn't want to stray too, the city decision makers don't want to stray too far from it because they don't want to get potentially sued and have a harder time either passing it, you know, getting it approved, or potentially having it overturned by a court. So there are things in the case of a planned development or a major rezoning, something that is a higher intensity, that there are things known as traffic impact analysis, the TIA, which asks the question, you know, what are the trip generation characteristics of this proposed use and density? So there's something called the ITE manual. The ITE is the Institute for Transportation Engineers. And that manual lists out all the types of uses, land uses, and there's basically a manual that says for this type of use, this is the vehicle trip generation, number for it. So, you know, if you're building a grocery store, it will, of this size, of this square footage, it will generate X number of vehicle trips per day or per hour or whatever it is. And if you're building a, you know, a Bass Pro Shop or whatever, this is the, it doesn't get that specific, but if it's building like a specialty retailer, it's going to get this level of trip generation. So then we can ask, how will that affect the LOS or level of service on state and local roads? Meaning, how will it impact traffic? Will it create queuing? Meaning, will there end up being, you know, cars queued up to turn in and out of it? What does that mean for pedestrian safety? If the car has to sit across what would otherwise be a sidewalk or crosswalk, what's that effect on air quality? If there's cars that are sitting idling and queuing up to get into access to a project site. What are the noise impacts? Has there been an acoustic study? So you can imagine for certain types of uses, there's very unique noise generation issues. An example I'm sure people have dealt with are backup beeps from facilities that take early morning and late night deliveries, backup, you know, trucks backing up. You know, the metal gates on loading docks. Where's the garbage? You know, how far is the garbage dumpster from the property line, and therefore, like, what kind of noises will that create for nearby property owners? And are there sensitive receptors nearby? Is there an old folks home or a school or something like that? What are the hours of operation of the facility? What about lighting impacts? So, you know, if you're going to build a parking lot or a tall structure, you're going to need lights on it. What direction are the lights going to face? Or is it going to spill into other people's windows? Is it going to spill in, again, is it going to affect sensitive receptors? How many rooftops are being created or destroyed? So rooftops is often a term that just usually refers to individual housing units. How will that affect the burden on the local school? How will that affect use of utilities like sewer hookups, housing stock? What is the potential effect on urban decay? Has there been an economic impact study? If you're building a big box store and there's a lot of local beloved businesses, has there been an economic impact study that will show how many of those businesses might end up closing? Which is relevant because that could have, if obviously empty storefronts on a street impacts a lot of things. It impacts safety. There's more dark spots on a street. You know, it can alter traffic patterns. It can lead to vandalism and other things. So those are measurable land use impacts. So when a community is engaging to deal with especially a major development like a planned development, but any sort of major rezoning or redevelopment, these are the types of land use impacts that, and this is just a sampling of them, that are really of concern. So what can we do? What can we do in these cases? We can organize neighbors, and in particular abutters, which mean people who live right up next to a site or very close by, to testify to us and eventually to decision makers about the current conditions. What are the current conditions in the neighborhood? Because they'll, the developer will show a nice site plan, and they'll show the leafy street, but what they won't show is this is a lot where kids play every day, because it's actually in this direction from the local elementary school, and this is a little grassy lot and kids play there every day. That's not necessarily going to be on that site plan, right? Other things, this is a lot people use as dog park. This is just, there's a lot of families on this street, and so the kids tend to be running across the street all the time. There's a lot of seniors or elders in the community who live in these houses because they're older houses. Their windows face, this new development, and there's going to be noise and light impact that could affect them and their health. So that's important information to get down and to understand. You're going to want to bring in, if possible, if we can get experts to testify to likely impact and technical deficiencies in applications. It doesn't have to be some, you don't have to necessarily go pay some consultant necessarily, but people who have knowledge, have some experience with some of these questions, who can look at it and say, like, are the trip generation numbers for this traffic study really accurate? Meaning, did they look at the right, type of use? Did they look at a grocery use versus a different kind of retail use, or et cetera? Questions about greenhouse gas emissions and car queuing and stuff like that. Residents should get together and talk about demands for conditions on approvals, particularly for these types of discretionary decisions like plan developments. What kind of demands would residents want to make a proposed development more welcome in their community? And we'll talk about conditions in a second. Ultimately, the process is political. So I definitely don't want people to think this is all legal and technical and engineering stuff. But the political case is clearer when there are specific and, in quotes, relevant concerns about the proposed development. The political case is clearer when you can speak to the community and to the relevant decision makers, and potentially ultimately to the courts, when you can tell a story about how the thing that's being proposed is actually going to have adverse impacts because of the nature of what it is, and not just because we don't like it because it's going to change the neighborhood. Not that that's not relevant or important, but from a political and even policy standpoint, I think it's important that that organizers be able to organize around those things and tell that story too, especially for things that might be high profile. And we'll get into examples of why that's important as well. Since the 2011 Municipal Code Amendment, the decision maker will generally be the decisions of the whether that's the council, the ZBA, or whoever. It'll probably be upheld by a court unless the decision doesn't satisfy these LaSalle factors I discussed. But the record needs to be created in front of the fact finder, even though they might end up admitting more evidence. So what that means is these things we've discussed, these land use impacts, your best bet is to get them in front of the decision maker. Get them in front of the ZBA, get them in front of the Plan Commission, get them in front of the City Council Committee on Zoning, so that they have them in front of them, so they can base their decision on those things, on those impacts, even though we ultimately understand it's a question of political power. If there's overwhelming political opposition or support for something, the decision makers will, in most cases, bend to that political power. We know that, but it eases the way and it protects you more ultimately on the legal side of it if you have created this case in front of these decision makers. So there's these sort of three general guidelines I put there at the bottom. Engage early, study closely, and organize nimbly, but not nimbily, not in the style of a NIMBY, a not in my backyard type person. And we'll actually go into why. So engage early. Like I said, depending on the type of zoning action, the public may not be notified until fairly late in the process that something is coming. If you live in a ward with a friendly and good alderman, as you do, that's less of a concern. But things can impact you that aren't just necessarily in your ward. And in any case, as a good practice, stay on top of these things. Your alderman and her staff are very busy and have a lot of responsibilities on them. So as part of co-governance and part of governing along with our electeds, it's our job to stay on top of this stuff too. By the time the community hears about something, there's a good chance the developer has been in meetings, if not with the alderman staff, then at least with the city staff, to get input on their application to make sure it's technically not deficient. If the alderperson discloses to the public that they've had these negotiations early, good, but organizers still should begin their work at that point. And that includes close study. Determine the technical requirements or criteria for that specific type of application. What are the findings that the decision-making body has to make? Consider the political impacts of the proposal and be prepared to educate residents and present evidence on all those things. And then organize nimbly. So, like I said, generally abutters or people close to the site will have more political sway, and they'll also importantly have more knowledge of potential impacts. Because like I said, there's often a lot of quirky things that you wouldn't be aware of, including the history of the site. So there was one project I worked on years ago where, an elder who lived near the site was able to tell us, back in the day, this site was used to treat wood. There was like a wood treatment facility there. And they used to just treat the wood out in the open. And so we determined that the soil was probably poisoned. There were probably toxins in the soil. And so we requested that there be soil drilling sampling done. And we were able to find that indeed, I can't remember the name of the chemical. It wasn't benzene, but it was something like that. The soil was full of it. And so if they were going to be moving earth, they were going to be sending those particulates into the air. And if we hadn't talked to that person who'd lived in that neighborhood all that time and who was aware of that, we would never have known that. At the same time, be aware that there will groups that will have a material interest for the proposal as well as against it. And depending on which side you're on, that can be, local community type groups, churches, whatever it might be, who have a financial incentive for something. Maybe the developers make promises or they've promised. This happened at the Atlantic Yards project in New York, in Brooklyn, where the developer promised to give office space to certain community groups, and so they ended up supporting the proposal. Often trades unions that represent skilled tradespeople, obviously, because that's how their members get work, they will be supportive of certain types of proposals. But be aware that NIMBY style arguments, this is going to obstruct my views, this is going to hurt my property values, how does this affect me personally? They're rarely effective, and they can actually work a negative effect. They can alienate people whose number one concern is the community and the general welfare of the community. People who do want to see more housing get built, or more, shops coming into the neighborhood, more options. Maybe it's a local food desert or whatever it might be. And those types of, I just don't want things to change, arguments are often not very effective, and in general, not a good, for organizing that's meant to address holistically an entire community, and beyond that, an entire city, doesn't really inspire a great vision, and in the end, doesn't connect struggles one to another. So examples of technical requirements. So when I said, be aware of the technical requirements of the application, this is in the case of a rezoning. The PD ones were too long to put in. An application for rezoning needs to include a narrative analysis that includes all these things: the floor area ratio, density, off-street parking, etc. Has to include drawings or renderings, photographs, and elevations that include all these things. Building orientations: where's the building going to be? Where's its ingress and egress going to be on the site? The entrance and exits. The bulk and scale of the structure in relation to what's around it. So that's why a lot of times you'll see elevation that show actually existing buildings and trees and people, so that people can get an understanding of its actual size. Where the curb cut's going to be and how will that affect sidewalks and pedestrians. And of course, like landscaping, garbage facilities, and screening, which usually refers to screening things like the garbage, but also potentially screening the site itself, where the loading area is going to be, and therefore where the truck turnaround is going to have to be if it's a commercial use. And then there's the required findings. So you'll find in the zoning code, it says, to issue such and such type permit, whether that's a rezoning or a special use or a variance, it will say, the decision-making body is required to make the following findings. And for rezonings, the required findings are consistency with specific area plans, if any. Some parts of the city have kind of overlay districts or specific area plans, the downtown loop area and stuff like that. The rezoning has to be appropriate given the character of the area and public facility capacity. It has to be compatible with surrounding use density and scale, and compatible with surrounding zonings, so no spot zoning. And the public infrastructure capacity has to be able to accommodate it. One thing to note, in the case of certain rezonings, surrounding property owners can actually force a supermajority requirement from the city council. If abutting property owners who own 20% of abutting properties submit a valid written protest, they can force a supermajority. So the city has required findings for all the major rezoning actions. Okay, I see that we're running along on time, so I'm going to, sorry, there's a lot here, so I just wanted to make sure I get through it. One thing, in terms of conditions, we've got some state power. The zoning application is sitting in front of us. It's time to use our power to get what we can from developers, but there's 2 Supreme Court cases that just coincidentally rhyme, these 2 cases, Nolan and Dolan, that limit the type of things we can demand from developers. So I'll zip through this. The developer comes in, they're applying for something. The community goes back and says, we can support this proposal if you provide us with certain things. If you set aside some of the land for a park, or if you set aside open space, if you contribute some money to the local school, because you're going to bring more students into the school, so we want to make sure it's not overcrowded, etc. What these 2 cases say is that any demands you make on the developer, as you can see here, they have to have a nexus to development, meaning there has to be a relationship between what you're demanding and the impact of the development. And the demand has to be in rough proportionality to the impact. So a classic example would be, if it's going to create a lot of vehicle trips that are going to require right turns, you dedicate some land from the property to be a right turn bay, a right turn lane. The political economy of land use. This is something that some of you may have seen in another presentation I gave, but there is overlap between development capital, major trade unions, and obviously small and mid-sized landlords, small business, and police. That affects a lot of the political decision-making that goes into land use. I was going to talk a little bit about the general iron permit and the lawsuit that was filed yesterday, because a lot of these issues, specific issues, came up in that lawsuit. But since we're getting towards the end of time, and I know we want time for questions, if people have questions about it, I'd be happy to talk about it, but otherwise I'll stop there. And I apologize for running a little long there.
And no need to apologize for that. I think that is on us for the late start, given what it took for people to get into the Zoom meeting. So we do not have any questions, open questions at the moment. So if anybody has any questions they would like to ask, go ahead and put them in the Q&A option. Otherwise, we have about, so the question came in, do you think they will win their lawsuit?
You never know how these judges are going to act, but it's a cause for concern. I mean, we discussed this question of like ministerial permits, like building permits versus like discretionary things. Basically what their suit is saying is the permit that they were seeking, the large recycling facility permit that they were seeking, was ministerial in nature, meaning once they met all the technical requirements, the permit must issue. And that's the argument among a couple other alternative arguments in their lawsuit. And they do have, they do have something of a point because of the way that the city structured the approval, which was they basically negotiated with this company, like, go move to this neighborhood, we'll help you transition there. They gave them a special use permit for this type of facility. The city drafted a 60-page rules document last June for this type of permit. Worked with with Southside Recycling to make sure their application met those rules. And the city basically wrote those rules for this facility. It's not like there was a long line of people trying to open large recycling facilities in Chicago. They basically wrote those rules for this applicant. Those rules came out in June 2020. The developer submitted their application. At first, it was rejected as being deficient. Then they met with them and accepted it, and they met all the technical requirements. So I don't think that it can be dismissed out of hand. So it's a concern. But it goes to show, one of the things they allege in their complaint is they say the city made a political decision. If you can get your hands on the complaint, and I think the CBS story on it had a link to it, you'll see starting at paragraph 36 in the complaint, there's a whole section in the lawsuit that says the city made a political decision as opposed to a legal one. And they point out in there, like, they bowed to political pressure. They ignored the technical requirements. And so, yeah. And it's almost exactly what we're talking about here. That's why it's important to make sure that there's these technical elements. I see a question from Rebecca. So there was actually a slide on this that I rushed through because it was running long, so I apologize. The city's affordable requirements ordinance was challenged on Nolan Dolan grounds in 2016. I'm sorry. Rebecca asks. Rebecca asks, the typical condition that we want to impose is greater affordability on residential development. How does this relate to the case law you just mentioned regarding exactions? So the city has an affordable requirements ordinance, the ARO. The ARO was challenged under the Nolan Dolan doctrine, these two cases on exactions. In 2016, the federal court that heard the case rejected the challenge. And they said the ARO ordinance itself does not violate the Nolan Dolan requirement. Seeking things above and beyond what the ARO requires, it will be a matter of degree. I mean, obviously any developer will resist it. And I assume if they felt like they were denied something because of a lack of support that was conditioned on a lack of enough affordable housing, their lawyer will say, that's why you were denied, the rezoning or the PD that you wanted. We're going to sue and say that it was unlawful because they were essentially demanding an unlawful exaction from us. And what would make it unlawful would be if the demand was so beyond the ARO scope and disproportionate to the impact of the development itself, that it fell afoul of the Nolan Dolan takings cases. So rough proportionality would be the way to think about it. Now, would that case survive in federal court? I don't know. I mean, the reality is a lot of times what happens, if we're being honest about it, is the corporation counsel, the city's attorneys, will come to the public and come to the local alderman and to this committee on zoning and say, if you guys do this, they're going to sue. And if they sue, we'll have to settle with them. And so, don't do this. And a lot of times that's enough to scare elected officials out of taking action. So in determining something that's safer to demand, just from that political side of it, rough proportionality would be the watchword. But it all comes down to political power ultimately, as we all know. There was that Logan Square proposal that was 100% affordable housing, and that was a little different because that wasn't just something that was being imposed on a developer, but it is possible.
Before we get into the rest of the questions, and we have one that came into the chat, and we have 3 that came into the Q&A, there are a few things I want to make sure I get through before we are at time. So Ramson, if you can stay a little bit past 8:30, and if the people with questions can stay a little bit past, hopefully we can get through them in a pretty timely manner. But first, if you are a member of 33rd Ward Working Families and you are interested in helping move us forward, on coming up with defined demands and things like that that we would like to make on developers. There is a form that you can fill out just to express your interest, and then we will follow up with you as we move forward. If you are not a member of 33rd Ward Working Families, but live in or near the ward and would like to organize with us, there is a link to join the organization. Since we've been talking a lot about zoning and building use, we are proud at 33rd Ward Working Families that we have an office space of our own that served as Rosana Rodriguez's campaign office, and then was converted into an office that is used by the IPO for its work. And we are looking to give it an upgrade that does not require special use or any other dispensations from the city, but it does require money. And so if you have some money to spare for us, the link that I just dropped there includes a way that you can donate to help that project, and gives a little bit of detail on what is going to be done in the project. And then finally, if you enjoyed this presentation, but do not live in or near the 33rd Ward, so you don't want to join up, but you would like to support us and help us keep putting on content like this and moving these sorts of things forward, you can sign up to support us in those ways. With that said, there is a question that came into the Q&A. In gentrifying areas, is there a legal basis to oppose luxury, high-cost housing based on incompatibility with current community or increasing property taxes to a level that would force existing residents out?
I think there's room for experimentation there. Like, the problem is that these things are so oftentimes so binary, depending on the community you're in and the, quality of your elected officials, which is that if you can't convince them, then your only hope basically is to try to get the entire rest of the city council to overcome the aldermanic prerogative tradition, or to take them to court. Or in some cases, the ZBA, convince the ZBA if the ZBA is the decision maker. So I think there is room for experimentation. I've had conversations with people before about this question of gentrification and if it is going to cause mass displacement. We looked at this in some other ordinances that were moved, and I think that there have been studies done on the effects of gentrification. There have been studies on the things that actually cause gentrification as well. I think we could experiment with both like encouraging those types of studies, that type of research to get done, talking to people who have been impacted and using that to build that kind of research, that kind of study, getting that kind of evidence in our hands, and bringing that in front of decision-making bodies and say, like, this is not just people saying, I don't want my, because that's the way they think of it, right? Like, people are just complaining they don't want their neighborhood to change. But this is not just that. This is actually talking about the human cost and the physical costs to the built environment of gentrification. And if we can start to experiment a little bit with getting that type of information together, putting it in front of these bodies in good test cases, these decision-making bodies in good test cases, I think we could start to build momentum behind just getting that to be a political understanding, in the same way that urban decay became something that people started to understand better as a actual result of letting people build big box stores wherever they wanted to. These big box stores were getting built and people were just like, it's great, more tax base. But over time, people started to understand it. It resulted in what are sometimes referred to as dark lots. Like there ended up being a lot of empty stores because of it. And that created a cost to the community in a variety of ways. It caused people to leave a neighborhood because they no longer had, access to commercial uses, and it's just also unattractive to have a big empty lot that's sitting there without any use, et cetera. So I do think there's experimentation to be done, but it requires a sort of systematic strategic plan and follow through,
The next question we have is, can you talk about how much sway individuals can realistically have on city council decisions in the current city climate for zoning changes, specifically in wards where the alder people do not have community-driven zoning processes or engage with the community on decision making?
This is one of the very complex things about the way it works in Chicago in particular, the way it's structured with the aldermanic prerogative, because aldermanic prerogative is our friend and our enemy. If your alder person is Rosanna or somebody like Rosanna, aldermanic prerogative can be your friend, because they can go to their colleagues and say, don't vote for this terrible project that's going to displace people, etc. And the assumption is so strong that the other aldermen will go along with them that oftentimes the developers won't even put in the application or pursue it unless they feel like they have a slam dunk case that they could take to court. But then the flip side of that, of course, is if you don't have one of those good aldermen, which 40 plus people in this 40 plus wards worth of people don't, aldermanic prerogative works against us, because if we can't convince that one person, you can't just go, it's hard to go lobby the rest of the city council zoning committee. But that doesn't mean it's impossible. And I think that there could be some, I think even though there's this lawsuit coming from Southside Recycling on this permit, I think the organizing that the activists did down there and that the community members did down there around that, which took a local, what in years past would have been thought of as like a local land use question, and exported it to the entire rest of the city through connection to organizations that were citywide and local organizations in other parts of the city. It showed that there is a stronger, there is a possibility to show that these are not just local fights. I mean, one of the very interesting things about the recycling plan on the southeast side is that the only other major recycling facility in the Chicagoland area is in Pilsen. And that shredder, that recycler, has been like working overtime since the north side one closed and pumping particulates into the air that people breathe there, right? And in fact, one of the arguments that recycling facility is making in their lawsuit is, if you don't let us operate, you're just going to have that Pilsen facility working overtime, and that Pilsen facility is old and doesn't have the safeguards we have, et cetera, et cetera. That's actually in their complaint, and it shows how these land use questions seem very local but are actually very interconnected, and we can build a citywide effort that can apply pressure to points like the city council committee on zoning that says, look, my alderman might not like it or might want this and is telling you to vote for it, but our movement is not just, our movement can move people in your ward, and we can maybe we can bend the stick or make the aldermanic prerogative more flexible. Yeah. So I mean, I do think it's realistic, but again, I think it takes a citywide organizing effort and a movement that has a strategic plan to execute it.
Lori Lightfoot campaigned on one of the things was ending aldermanic prerogative, so I'm sure that's right around the corner.
But again, sometimes it's our friend, and also you can't end it. It's an informal custom. Like the courts have basically said that. They're like, "What do you want us to do? Yell at every alderman for agreeing with each other? We can't do
that." We have a question. Given how opaque it is to monitor developments if you don't have a friendly alder, do you have suggestions or strategies we can use to find out about bad developments in advance enough to actively organize against them?
One of the great things about groups like 33rd Ward Working Families is that you all have a great combination of things, which is you have the people, right? And you have the people with knowledge and experience of how the city works on a basic level and a fundamental level. And so I think it's hard because certain things are exempt from even the Freedom of Information Act. So drafts of documents are exempt from FOIA. They don't have to be produced. And so a lot of times, even if you submit a regular Freedom of Information Act request that says, for example, like, send me all applications for a rezoning or whatever, or a PD, if that application is still in draft, the city can arguably not disclose it to you on the grounds that it's a draft, it's a documented draft. Now, there's been some attorney general opinions and stuff about that, about what they can exactly hide, but they can at least delay you. So, but a group like 33rd Ward Working Families that has its ear to the street, right, and knows where something has been, like a building is being sold or closed down or has just been purchased. The people that know that are the people that live on that block because they hear it, right? Or the property owner who, or the I'm sorry, the business owner, the small business owner, or the employee of a small business owner who works in that building and says, "Hey, I heard they just sold this building," right? And only a group, like an organized group, can systematize that kind of rumor and scuttlebutt or whatever into like keeping your ear on the street. Let's make sure if this information comes in from anywhere, we're putting it into a central place, and it's somebody's job to follow up on that. It's somebody's job to say, like, we heard this building got sold, so let's talk to the DPD, let's file a FOIA request, you know, let's make sure we're following up to see, hey, this building got sold. Have there been any applications submitted? Have there been any conversations about what this property is going to be used for? Or if there's an empty lot that's been sitting there forever. So I think regular Freedom of Information Act requests, where you know what you're requesting, any applications for rezonings, PDs, whatever, or, you know, any communications that regard this list of properties that are we think important targets because they're in a sensitive place. You know, they're at the edge of the gentrification, or, you know, it's a big empty lot, so everybody's kind of nervously been walking around it for years wondering what it's going to turn into. Regular Freedom of Information Act requests, and having a plan in place for the organization to, you know, if that piece of rumor comes in from anybody, you know, they know who to talk to. Like, Nick we're going to call Nick, one of the Nicks. We're going to call one of the Nicks, and it's one of the Nicks' job to follow up on that. Nick's volunteering for that, he told me. So
yes, of course. And is it possible, just as a personal follow-up, to just delineate a part of the like, how specific would a FOIA request have to be? Like, could we just say in the 33rd Ward, or would it have to be specific to streets, address ranges, things like that?
If you did it for the 33rd Ward, you'd probably get, and I know you have some very talented and experienced journalists in your squad as well who could school you on FOIA. But if you do it for the whole 33rd Ward, you're probably going to get a response that's like, that's burdensome. You're asking us to look for every possible thing. The thing is, though, a lot of the applications ask you to list the ward. So that's the other thing to do, is go to the DPD. They have them on here. They have all the application forms. So look at the application form and see, like, what information does the application form request, right? Does it ask just for address? Does it say ward? Does it ask for the census tract? Or just check the application. So, you know, like any application where the answer to this question is this, we want that application. Give us a copy of that application, right? Familiarize yourself with different applications so that the forms, so that you know, so that you can make your request more specific. If you do 33rd Ward in a specific form, it's more likely to get a response. If you just do 33rd Ward in like all zoning related matters, you know, they're going to be like, that's infinity things. We're not going to give that to you.
Okay, we've got 3 more, and unless anybody has more questions, I'm going to close it at this point or in the next minute or two. So if you have questions, get them in. Any thoughts on recent 606 Pilsen multifamily preservation districts deconversion demolition fees in regards to takings or Nolan Dolan? Sorry if that was hard to follow.
No, I got it. One of the things I really hope comes out of this is I hope people just start using Nolan Dolan all the time, because it is it is nice that we got like a nice rhyming thing in the law. The preservation districts, I didn't go over preservation districts because they're kind of their own thing a little bit in the zoning world. They're analyzed under a different set of, not a different set, but like a different part of takings law. Usually it's referred to as the Penn Central test. There was a case in New York regarding Penn Central. And preservation districts are like pretty well protected. Like, you can impose preservation districts. Like, it's very hard for people to sue and say you're taking my property because you're imposing a preservation district, unless there's very specific, you know, unless they're very overreaching. The other one, though, is moratoriums, which this might actually refer to obliquely. Moratoriums on certain types of development activity Like a moratorium means you're not allowed to demolish anything. You're not allowed to build anything of this type in this area. Moratoriums will be considered takings unless there are specific exigencies or like contingencies put into them. They can't be permanent. They have to be like, they have to have a date certain where they end. That date can't be too far in the future. And you have to allow there to be some out. So like some people have to be able to get around the moratorium in emergency or specific sets of cases. There has to be some mechanism in there to allow people to get around the moratorium just in case. And you can specify like only in these types of cases. Like for example, if your building is collapsing or if there was a fire, right? Like the moratorium doesn't apply to you. If you don't have stuff like that in there, it can be considered a taking. The prohibiting deconversions is obviously very big because that is a major tool for deconversions can be a major tool for gentrification because people move into something that housed 3 families and then deconvert it into something that houses 1 family. And you can see how that affects the housing stock over time. They're all pretty well insulated from Nolan Dolan in general because they're not really exactions. They would fall under a different type of takings law, which is the Penn Central regulatory taking, which is like a 5-factor test. And that has been litigated to hell and back, and they're pretty well protected. The city knows how to write those to avoid any takings challenge. The only time it comes up is really moratoriums.
We have a question. In most cases where an organized community is battling a developer, the developer's zoning lawyer provides not only legal representation, but research, contacts, spokespeople, services, etc. It creates a very imbalanced situation, which is different from the adversarial parts of the legal system. Have any other US cities with left organizers come up with creative ways to correct that imbalance?
So over the years, I've been involved. So I'm also licensed to practice in California. And briefly after law school, I'm from Chicago, born and raised here, but briefly after law school, I lived in California for a little over a year, about a year. But I'm licensed there and I do practice land use there. And it's very different in California. And have been involved in a lot of these types of site fights, as we call them. And it's not always left groups, although it's usually a blend of environmental groups, left groups, and then some sort of just like NIMBY adjacent type folks that get involved with this. But you're right, there often is an imbalance. And if I understand your question correctly, I think the answer is that part of the way to address that imbalance is to, again, it's very hard for when it's just an ad hoc basis, like a group of neighbors coming together to fight a specific developer because they just found out about something they don't like. But when you have an organized movement, it's easier because there's institutional infrastructure and memory. So I think it's important to, again, have a plan and over time cultivate relationships with like, call people at the local college or university, like whatever that is, where you know that they have like an environmental studies department. And be like, do you have any, is there a professor or a grad student there or something who would be willing to like pitch in to help us study how is this going to affect the river, or how is this going to affect the ambient air, or, people who have expertise in like rehabilitation to talk about, does this kind of acoustics affect people in a certain way? Would you be willing to write a comment letter for us, or do like a sort of informal study? I remember in certain cases out in California, we just found retired academics who had done transportation engineering, and we just gave them, there's like, they use these like clicker counter things. And we're like, would you be willing to just basically go with one of our guys and train them how to count cars? And so that we can submit evidence that shows like there's already this many cars going past this intersection. And it's going to triple that number. But it takes time to cultivate those kinds of relationships, and it takes a permanent group with institutional memory and people who can develop those relationships. And I think over time you can start to correct that balance a little bit, because you're right, anybody who does environmental studies, traffic studies, architectural studies, whatever it is, they don't get into that business to work for 33rd Ward working families. They get into that business to work for developers. That's who writes them checks. So even if you were willing to pay them or able to, they're not going to be very happy to be appearing against a developer for a project. So So yeah, I mean, it's creative, but you can just go along those lines, you know, find people. The community is a great resource. There's a lot of local educational institutions, you know, people who might be willing to just pitch in and help, and you know, raise a little money if you know it's work that would require a little bit of pay. But yeah.
And then the last question we have, appropriately enough, is more of an open-ended, I think. What kind of policies or ordinances do we need to advocate for to make developers do what we want instead of what we don't want?
Right. Um, the ARO is a good start. Um, I think creating funds that developers have to pay into, the zoning code should be amended to require a more intensive public participation element to it. The fact that the ARO was able to withstand the Nolan Dolan challenge, the Affordable Requirement Ordinance was able to withstand the Nolan Dolan challenge, and pretty easily. I don't even think it got appealed. I think it got resolved at the district court, and the developer got such a beating that they were just like, you know what, I'm not even going to bother appealing this. Means that, you know, we can put more stringent requirements um, into the zoning code. Those can be written into the zoning code. We can put more stringent public participation. For example, somebody mentioned earlier, what do you do if you live somewhere where the alderman isn't friendly and they're not going to give us notice? You can require that notice happen. You can say, I mean, this exists in some other communities. You can say, like, as soon as there's any contact between a developer regarding a parcel and a potential application, some kind of notice has to be created. They don't have to send a letter to everybody, but the city planning department has to say, like, there's been a letter of interest expressed about this property or something, so that you just have somebody who monitors it, right, and can establish contact with that person. Um, city funding for um, city funding for groups to engage in planning. Um, city planning education for communities, a more active city land purchasing program itself, so that the city owns more land, because when the city owns the land, they can record stuff onto the deed, covenants onto the deed, which means anybody who buys the land has to abide by those covenants. That's actually how the Affordable Requirements Ordinance works, is that the city requires things to be recorded on the deed in exchange for an upzoning, is basically how it works. And the thing that gets recorded on the deed is that the rent can't be above this much of the average median income or whatever. That's the way the ARO actually works. If the city owned more land, they could just do that itself. The other thing would be that we need to start, and this is why I think it's really important not just to think on the city level. We need to start thinking about regional and state planning bodies, which other states have. I think Oregon and Washington are two places I've been in, where there are state bodies that handle at least zoning appeal type stuff, where residents can be like, you know, this plan is not good, we're going to bring it up to this higher body. But if you have some kind of state and regional planning bodies with authority that are community led, like the Citizens Utility Board, sort of, although I know that's not perfect, but that idea, that concept, you can drag these things out of this very local fights where the communities are almost always at a disadvantage, and scale them up, not dissimilar to the idea behind the elected representative school board, so that these planning decisions aren't just like a neighborhood by neighborhood by neighborhood thing where we're always fighting. And we just, you know, we beat the developer here and he's like, okay, I'll go one neighborhood over and build it there, where the community is less organized and the alderman's more friendly. And have you really solved the problem? You've protected your neighborhood, but you know, our neighborhood is in a city and our city is in a state. And so I think that's why it's important to also be thinking about, you know, how are we getting people elected to state office? How are we interacting our political power locally with our political power at the state level? Um, and I think it's going to take all those things interacting together to really make sure that from every direction we're able to put pressure on capital when it comes in to build, until we decommodify all this stuff, right? and end private property. So long as we rely on capital coming in to build things, we're able to pressure them at the local level, at the state level, at the regional level, so that, you know, if capital can come in and it can build, but it's going to build according to a regional plan, a state plan, and a local plan that serves the general community interest.